innovation, drives progress, and leads to breakthroughs. Competition law, often hailed as the guardian of free markets, serves as the bedrock upon which the edifice of economic fairness and consumer protection rests. With the constantly evolving world, rapid strides are being taken at national and international level to bolster free and fair market competition.
Good evening, ladies and gentlemen.
I, Lakshita Daga,
And I, Arun Chatterjee, welcome you all to the inaugural ceremony of First Justice Hidayatullah International Moot Court Competition 2024. We also welcome our guest of honor for today, Professor Dr. Dilip OK, Honorable Vice Chancellor, Maharashtra National Law University, Mumbai. We also take the privilege of welcoming the judges for the event, revered members of faculty, distinguished alumni, participants, members of press and students of HNLU.
we are excited to highlight that after 13 editions of Justice Hidayatullah National Moot Court Competition, HNLU has taken this moot international for the very first time. We look forward to hosting participants from across the world.
On that note, may I now request all to rise and join us for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
शुभम करोति कल्याणम आरोग्यम धना संपदा शत्रु बुद्धि विनाशया दीपा ज्योति नमोस्तुते.
I invite the esteemed dignitaries present on the dais to kindly light the diya in honor of the commencement of the inaugural ceremony for the First Justice Hidayatullah International Moot Court Competition 2024.
May I now request the Organizing Secretary of HIMCC, Dr. Anindya Tiwari sir, to deliver the welcome address.
A very good evening to all. Respected Honorable Vice Chancellor, Professor Dr. V.C. Vivekanandan sir, esteemed guest of honor, Professor Dr. Dilip Uike sir, Registrar in charge, Dr. Vipin Kumar sir, distinguished guest, faculty members, students and participants. I am honored to welcome you all to the inaugural ceremony of First Justice Hidayatullah International Moot Court Competition 2024, organized in collaboration with AZBN partners and hosted by Hidayatullah National Law University, Nawa Raipur. This event marks a significant step forward in our commitment to promoting excellence in legal education and fostering meaningful discourse on international antitrust law. With 40 teams, including 3 international teams, participating in this competition, we are privileged to have some of the brightest legal minds from around the world come together to engage in rigorous legal analysis and advocacy. The proposition for this competition was drafted by AZB and partners, which focuses on international antitrust laws, presenting a challenging and timely issue for our participants to address. I extend my sincere gratitude to our Honorable Vice Chancellor, sir, and our esteemed guest, Professor Dilip Uike, sir, for gracing this occasion with their presence. Your support and encouragement are invaluable to us. I also want to express my appreciation to AZB and partners for their collaboration and expertise in drafting the Moot problem, as well as to our faculty members, students, and organizing committee for their dedication and hard work in organizing this event. To the participants, I encourage you to make the most of this opportunity, engage with your peers, learn from each other, and strive for excellence in your presentation and arguments. Remember, competitions are not just about winning, but about knowledge and experience you gain along the way. As we embark in this exciting journey over the next 3 days, I wish each team the very best of luck. May this competition be a platform for intellectual growth, professional development, and lasting friendship. Welcome to HNLU. Jai HNLU, Jai Chhattisgarh, Jai Bharat.
Thank you so much, sir, for your enthralling words. We request Mr. Anirudh Agrawal, Student Convener, HIMCC, to tell us more about this Moot Court competition.
Ladies and gentlemen, esteemed judges and fellow participants, I extend my sincere gratitude to each and every one of you for gracing us with your presence on this auspicious occasion. Today heralds the commencement of the first edition of Justice Hidayatullah International Moot Court Competition 2024, a flagship event of Hidayatullah National Law University. It is with profound honor that I stand before to address a distinguished gathering amidst the stellar presence of luminaries such as Professor Dr. Dilip Uike sir, Professor Dr. V.C. Vivekananda sir, the Honorable Vice Chancellor of the University, Honorable Registrar Sir Dr. Vipin Kumar, Dr. N. Tiwari sir, all my respected faculty members, and my dear fellow students. HNLU, established in 2003, has traversed a remarkable journey spanning over 2 decades. The towering achievements and unparalleled expertise attained by HNLU in the field of legal education within such a short span of time are truly commendable. Our esteemed institution pays homage to the illustrious legal luminary Justice Muhammad Hidayatullah, after whom it is named. The ethos of HIMCC 2024 resonates with the principles upheld by the Honorable Justice M. Hidayatullah, who evidently believed in nurturing young legal minds and shaping their future. Since its inception, HNLU has lauded for its commitment to delivering the highest standards of mooting experience. Over the past decades, HIMCC, earlier known as HMCC, yes guys, we are going international this year, has earned renown within the legal fraternity as one of India's premier moot court competition. Aligned with the ideals of Justice Hidayatullah, HIMCC 2024 endeavors to cultivate critical thinking and ignite the legal acumen of aspiring law students, providing them with a robust foundation for their future careers. Sir, this HIMCC 2024 marks the beginning of a new chapter, not the HNMCC of 2023. And sir, I'd like to thank you for giving us this opportunity to invite participants across the globe, and I know for sure that this marks the beginning of a golden era of mooting at HNLU. Thank you so much, sir.
Thank you, Anirudh.
May I now request Professor Dr. V.C. Vivekanandan, Honorable Vice Chancellor, HNLU, to felicitate our guest of honor with a bouquet as a token of our respect. I request the dignitaries seated on the dais to kindly join.
Thank you, sir. HNLU has touched numerous milestones under the able guidance of our Honorable Vice Chancellor, sir. Sir has also been recently elected as the president of the Consortium of National Law Universities. His revered persona doesn't need much introduction. We are glad to have you as our Vice Chancellor. We request you to kindly address the gathering.
Good evening to all of you. Professor Dilip Uke, Honorable Vice Chancellor of Maharashtra National Law School of Mumbai, Professor Vipin Kumar, Registrar of HNLU, Dr. Anindya Tiwari, Head of the Moot Court, a good friend of HNLU for a long time. I remember in the testing times of COVID, when we had a marathon online recruitment of faculty running around 9 days, from morning to evening, of course online, he was one of the members who sat through all the 9 days. Later on, we were sitting in many of the interview boards, and he had an illustrious career as a HOD in Pune University Law Department. Later on, took over the mantle of MNLU Mumbai for 5 years, and he is again reappointed for a second term very recently in Mumbai, and I'm very happy when I invited him to come and join us. He readily said so and is with us. So on my behalf, I welcome you, Professor Uke. This was announced last year in the same time, and the energetic team of faculty and students of HNLU Moot Society, headed by Professor Tiwari, has actualized it with foreign teams entering the fray this year. Moot courts stand as an integral component of legal education, providing a simulated court or arbitration setting where students can apply legal theories and practice the craft of argumentation in a competitive environment. This educational tool bridges the gap between theoretical law studies and the practical aspects of legal practice, offering numerous benefits that contribute to the comprehensive development of aspiring legal professionals. Barack Obama, the ex-president, once observed, the study of law can be disappointing at times, a matter of applying narrow rules and arcane procedure to an uncooperative reality, a sort of glorified accounting that serves to regulate the affairs of those who have power, and that all too often seeks to explain to those who do not the ultimate wisdom and justness of their condition. But that's not all the law is. The law is also memory. The law also records a long-running conversation, a nation arguing with its conscience. This is what Barack Obama said. Indeed, mooting is a silver lining in such a grind. The real court is more complicated and surprising than the life at a law school. Moot certainly cannot match the twists and turns of reality of legal practice. Moot certainly cannot anticipate the storms and tornadoes of reality in courtrooms. Yet, they prepare one to absorb the intensity of such shocks and turbulence. To be an active mooter helps one to hit the road and run than waiting for a training session after enrollment. The real world legal practice does not shower such charity on those who are unprepared. To list out few exposure basics, what a moot can do for not the mooters who are ready to battle from next 2 days, but those who have come here to observe and try to initiate themselves. It is in the first place a practical experience in a controlled environment, of course. It offers students the chance to engage with practical aspects without the real world consequences. But this experience is very invaluable for understanding the dynamics of a courtroom proceedings, the importance of procedure, the nuances of legal practice that can be fully appreciated through text, not only through textbooks. Second is development of research skills. Preparing for moot court requires extensive legal research to support arguments and to counter the opposition claims. Students learn to navigate the legal databases, identify the relevant procedures, interpret the statutes, and apply the legal principles to the facts of the case. Third is enhancement of legal writing. The preparation of memorials and briefs for moot court competition hones your legal writing skills. Students learn to construct persuasive arguments, articulate complex ideas clearly and concisely, and adhere to formal legal writing. Fourthly, oral advocacy and public speaking skills. Arguably, one of the most important part of moots is the contribution to legal education in the development of oral advocacy and public speaking skills. Participants must learn to think on their feet, respond to judges' questions, and articulate their arguments confidently and coherently. This practice is crucial, as the ability to speak persuasively and maintain composure under pressure is essential for courtroom advocacy and many other aspects of legal practice. Finally, critical thinking and analytical skills. Moot courts challenge the students to critically analyze legal issues, anticipate counter arguments, and creatively apply the legal principle. This process enhances their ability to critically and analytically navigate through a maze. So, in conclusion, moot courts are cornerstone of legal education, offering a practical, hands-on approach to learning that complements academic studies. They prepare through research, writing, advocacy, and analytical skills. It importantly encourages teamwork, networking opportunities, and build confidence, all of which are essential for a career in law. By simulating real-world legal challenges, moot court ensures that future lawyers are not only knowledgeable about the law but also as effective communicators. To close my opening remark, with 40 teams, 80 judges, and 100 volunteers, there cannot be anything more exciting than HIMCC. As they say, there is one universe, 9 planets, 7 seas, 809 islands, 204 countries, more than 1,000 moots, but there is only one HIMCC. Welcome to HIMCC. Thank you.
Thank you so much, sir, for your inspiring words. It is a matter of pride and honor to have Professor Dr. Dilip Uke, Honorable Vice Chancellor of Maharashtra National Law University, Mumbai, with us today. With a rich academic and administrative background, his previous roles include Pro Vice Chancellor and Acting Vice Chancellor at SRTM University, Nanded, and Professor and Department Head of Law at Savitribai Phule, Pune University. An internationally recognized legal scholar, Sir has been a visiting research fellow at New South Wales University, Sydney, and a recipient of a UGC fellowship for research in France. Sir's expertise in jurisprudence, constitutional law, and administrative law is widely respected, marking him as a luminary in this field. We now humbly request our guest of honor to kindly address the gathering.
My close friend, as well as Honorable Vice Chancellor, Hidayatullah National Law University, Raipur, and newly elected President of Consortium of National Law Universities, Professor V.C. Vivekanandan, Registrar of HNLU, Deans, faculty members, all the participating team members and dear student friends. A very good evening to all of you. It is a matter of great privilege and honor to be here today for the inaugural of first Hidayatullah International Moot Court Competition being organized by HNLU Raipur. It is an honor. Why? Because it is not only an international moot court competition, first international moot court competition, but in the name in which this competition is being organized. I hail from the same college, where from Justice Hidayatullah completed his law graduation. Secondly, it is not the only international moot court competition. I would say that with the dynamic leadership of Professor Vivekanandan, he has put and is putting, along with his team, HNLU on international map, not in terms of only moot court competition, but in terms of the legal education as such. Reason is that it is not because since he has invited, since we are friends, that's why I am saying this. We in the legal field, in the legal fraternity, it's a small one, though it is a big country, but we know each other. That being so, we know what the HNLU was and what the HNLU is. There is a stark difference between what it was and what it is now and what it is going to be in future. Rather, I was talking to one of your faculty member in the morning itself that it has become possible, and it is possible because of the sacrifices being made by the leader. One outside world may not realize this, outside world may not know this, but we as friends, because we continuously meet each other, we continuously interact with each other, and that's why we know well that kind of sacrifices which are being made, and then the kind of hard efforts and work which is being put, of course along with the good team, and that's how any institution, the success development of the institution lies in that. And that's why it is a privilege, and that's why it is an honor to be here with all of you. Dear friends, firstly, as Professor Vivekanandan as well as the previous speaker who had pointed out that why the moot courts are important, one necessary one. Noted jurist, you might have read or heard Justice Holmes. He said, life of law is not logic, but it is an experience. I would say the same thing in a different way. Life of legal education is not logic, but it is an experience. And that's how that core of experience of legal education and then the legal profession, you get that feel in terms of the moot court competitions and mooting. I do not wish to repeat those things what Professor Vivekanandan and earlier speaker, both of them have said that. But when we talk about the legal education and then clinical legal education, wherein the moot court is an essential component of the clinical legal education. As it has been pointed out that you get an hands-on experience. It is a kind of an experiential learning of law, practical learning of law. Though it is a mock, though it is a moot, nevertheless, real laws are to be employed, real laws are to be interpreted, of course based on facts. And then even the real decisions as a precedent you need to refer to. Dear friends, when you prepare the moot court competition or when you study, technology is an advantage for you people, this young generation now. However, I would say at the same time, it is not merely the text which is an important one, but rather it is the context in which that law has been made and that law has to be applied and interpreted. That is more important one. That is one. Hence, it is necessary to read, to go through the real standard textbooks for preparation of which you must have been doing definitely. Having said that, it is not the law alone, because there is a law beyond the law. And that beyond the law lies in the decisions delivered by the highest court of any of the country, highest court of the land. As we call it as a precedent. You also, during the course of your argument, rely upon certain decided cases, certain precedents. As we know that it gives you the kind of a knowledge, it inculcates in you the kind of analytical skill, critical thinking, argumentative skill, advocacy skills, not only a knowledge. However, when you read, when you rely upon those precedents, my not an advice, it is my own opinion, that what we witness, what we experience, that largely we rely upon only the technology. We rely upon only the head notes of the decisions or paragraphs of the decisions. Initially, the gist which is given. What is important is that please go through the original decisions. Once you go through the original decisions, you will realize that the kind of an arguments, kind of contentions which have been advanced by the contending parties, and the kind of interpretation and analysis which they offered during the course of argument, that would be very, very handy, useful, beneficial to you. Similarly, when we talk about any of the decision, we ought to know that what is binding. Is it the whole decision which is binding, or is it only some part of it which is binding? The reason is that you might say, you might think, yes, we know it is only the precedent in the form of ratio which is binding. But one need to know what is ratio. One need to know what is the authoritativeness, or where the bindingness or authoritativeness lies in, how to trace that. Of course, first and foremost, the majority decision is to be distinguished, is to be separated from the dissenting one, from the minority one. However, the minority or dissenting opinion is good, it is not binding. Secondly, that authoritativeness or bindingness which emanates only from the majority decision, which part is a binding one, which part is an authoritative one, that we need to ascertain. Sometimes what happens, that in the course of argument, an advocate, a lawyer may say something, and that could be viewed, that could be treated as a binding ratio. One instance I would like to share with you. S.R. Bommai, all of you must have studied or heard of or read also. That decision is in relation with the Article 356. During the course of argument, then the noted lawyer, he is no more now, the great legal luminary, Advocate Ram Jethmalani. During the course of argument, he referred to the Representations of People's Act. And previously there were some decisions delivered by the Supreme Court in relation to Section 123 and 3A of the Representations of People's Act 1951. Times of India immediately on the next day carried that editorial pointing out that previous decisions have been overruled by the Supreme Court judgment by virtue of S.R. Bommai. Without realizing, without understanding that it was merely a reference, it was merely an arbiter, it was not the issue of the matter, issue of the case. And that's how we carry, because Times of India is a standard newspaper. And when it is written in editorial, even the lawyers took it as a sacrosanct one, a sacred one, sacred truth as such. It is not so. Hence, it is necessary to read the original judgments to understand that where the law lies in, where the bindingness lies in. Similarly, other aspect is, this may not be the forum, whether that decision is binding, it doesn't depend only upon the ratio. Whether that decision delivered by the court, delivered by the Supreme Court, even if it is it a per incuriam decision? Per incuriam decisions are not at all binding upon the lowest court of the land. Now one must know what is the per incuriam decision. Per incuriam decision of the Supreme Court also is not at all binding upon the lowest court of the country. Those technicalities, those conditionalities, one ought to know. Why? Because otherwise you will be countered by your opponent party. Per incuriam decision is the decision wherein the court decides the matter, delivers the judgment without relying upon any existing law as such, or either statutory, constitutional, or even the judicial one. Such decision is the per incuriam decision, which lacks a complete authoritativeness or the bindingness. It is not at all a precedent. As I said, and you also know maybe, that even the lowest court of the country is not at all bound by such a decision, even though it is a decision of the Supreme Court. That is another aspect. As I have said initially, that there is a law beyond the law, and that's how you need to rely upon and you need to read the original judgments, because of two reasons. Firstly, that there are certain flavors of the decisions. One may wonder that we have not heard about the flavors of the decision, we have not heard about the flavors of the judgment, we have heard flavors of ice creams, that's all. How could there be a flavor of a judgment? Yes, that's true, but otherwise, if you read old judgments delivered by Justice, say, for example, Justice Krishna Iyer, you'll find the flavor of humanity, you'll find the flavor of compassion, you'll find the flavor of karuna, you'll find the flavor of human rights jurisprudence in that. We read the judgments delivered by Justice O. Chinnappa Reddy, you'll find the flavor of notion of social justice there. So for those flavors, one need to read the original judgment and the philosophy which has been employed by those judges while deciding those cases. That is one reason. Secondly, for the same thing, for the same reason, there is a law beyond the law. Law may remain the same. However, its interpretation and application may undergo a change by virtue of the decision delivered by particularly highest court of the land. Positive express provision may remain the same in the text, yet its interpretation and application both could undergo the change. Two instances, all of us know well, all of us know very well. One is Maneka Gandhi, Article 21. I do not want to refer anything about that. The word due is not there yet, even now at this moment. On 15th March 2024, the word due is not there under Article 21, but since Maneka, that word is being read and applied post Maneka Gandhi when it was decided in 1978. Procedure established by law now essentially mean the due procedure established by law. The word which is not there came to be read. Another one, same, S.R. Bommai. S.R. Bommai, which was in relation to Article 356. Under Article 356, the word otherwise is still very much there even at this moment. The state government, the precedent rule could be imposed whenever the governor submits the report that there is a failure of constitutional machinery in the state, or otherwise. It means even without the submission of the report by the governor. And that was happened so in 1991 in Tamil Nadu. However, post Bommai, Supreme Court refused to read the word otherwise under Article 356. The report of the governor submitted to the president that there is a failure of constitutional machinery in the state is an essential one, is must. In one case, the word which is there, Supreme Court had refused to read that word. In another case, the word which is there, Supreme Court had refused to read that word. In one case, in Maneka, the word which is not there, Supreme Court read that word. In Bombay, the word which is there, Supreme Court had refused to read that word. See the law. That is the law within the meaning of Article 141 of the Constitution. Law, any decision delivered by the Supreme Court is not the decision, is not the judgment. But that is the law within the meaning of Article 141. That decision is not only binding upon the parties, that decision is not binding only upon the courts, including the Supreme Court, but that decision is binding even upon the administration. Any decision delivered by the Supreme Court within the meaning of Article 141 has this 3D, three-dimensional value, binding upon the parties, binding upon the administration, and binding upon the courts. In view of this, it is necessary to read the original judgments for these reasons as such. Dear friends, having said this, that both Professor Vivekanandan and previous speaker, they pointed out why the mootings are required one, why the moot courts are required one. Winning and losing, that is the part of the process. All the 40 teams cannot win the competition. However, I take a liberty at this occasion that you must try your best to win. Yes, winning matters. I know that the kind of prizes which have been kept for this, for winning team from the first runner-up and the second also, that matters. Winning is winning. So that is a practical thing. Yes, everybody wants to win, and hence everybody need to perform at their best of their ability. That is one. However, as I said that I would like to take this liberty just few minutes, that I know there are the teams participating from the neighboring countries like Bangladesh and Nepal. It is just like India, both the countries. Their constitutions and constitutional provisions are more or less like Indian constitution. In view of this, dear friends, you are young. Whole life is ahead of you. Whole career is ahead of you. I do not wish to go philosophical. However, what I would urge and appeal to all of you is this, that whenever you enter into your profession, whichever, we know the national law universities, majority of the students go for corporate. Litigation, how many would enter, we do not know. There is a very, very less number that is to be encouraged. And when you are participating in the moot court competition, ensure that you will also enter into the litigation practice. Of course, it is a freedom of choice. It is a matter of choice. That is not the compulsion. One more important thing, dear friends, all of us are not only citizens of this country, but all of us are the part and parcel of, integral part and parcel of this civilized society. We are being governed by the supreme law of the land, which gives us freedoms, liberties, rights, which are fundamental. Justice, social, economic, political liberty of thought, expression, belief, faith, worship, equality. But we are obsessed with only these three, and we are more obsessed with our fundamental rights. And nowadays, my right to privacy has become so much so close to hearts of young generation. Why only justice, equality and liberty? What about that notion of the fourth pillar, a notion of fraternity, which is also equally important, or rather more important? And it is not only merely the principle, it is not merely the concept. Rather, it has been made as a duty in Part 4A, 51, Article 51, capital A, small e, if we read. Human dignity and common brotherhood. Fraternity is what? It is a common brotherhood. Whose duty it is to ensure that there will be a fraternity? Is it the duty of the Constitution, Parliament, Supreme Court, legislatures, governments, then whose? That is the duty of each one of us. If you look at the atmosphere, our thought processes, our thinking has become little narrower one, particularly in last, say, decade or two. Why it is so? Why the atmosphere has become little uncomfortable? Why can't we think that all of us are human beings, and being the human beings, as I have a right, others also have the equal rights, similar rights? Why can't we treat each other with equal human dignity? Why can't there be in real sense, the fraternity? If we adhere to this constitutional goal, now we are celebrating the 75 years of the Constitution. We do read the preamble on every year on 26 November, every institution, everywhere. Is that reading sufficient one? Is that studying preamble is sufficient one? Is that writing in the examination sufficient one? Or publishing a paper in any of the Scopus Index journal is sufficient one? What is more important is the reality, harsh, naked reality. Unless we adhere to this goal of the Constitution in the form of fraternity, till then, we need to ask the question to ourselves. It might sound a little offbeat, but that is necessary. We shall ask this question, we shall pose this question to ourselves. Are we in real sense civilized? Are we really civilized one? If not, then how the society could be made as a civilized one? Unless we adhere to our fundamental duty, which is casted upon us by the Constitution, unless we adhere to the notion of fraternity, and this is the, you are coming together from different parts of the country along with the neighboring country, take the advantage of this, adhere to this, spread this message and try to follow. This is my opinion, not an advice. Otherwise also, advice is not binding at all. When it is not binding upon the President, if Supreme Court gives, why it will be binding upon you? But it is my humble appeal to each one of you that these are the occasions, these are the platforms wherein when you come to know each other, as well as the institutions like national law universities, wherein students come from whole country, please follow this, and that will give you, because I know well, I am conscious enough. I am not addressing the law students. You may wonder, how do I say this? I am conscious enough that I am addressing future Justice Chandrachud's, future Justice Nagaratna's, future Harish Salve's, Jetmalani's, so on and so forth. Maybe Ambani's or Adani's, who knows? Maybe chief ministers, or could be a prime minister, who knows? That's why I am conscious enough about this fact. And I am not saying this just for the sake of saying. Truly, do you know your future? Do you know your tomorrow? No. We are not astrologers. Even astrologers in true sense also do not know. Even if you go, whatever they say sometimes doesn't happen. That's why. Keep that hope. Keep that confidence. What is important is to have the confidence. Yes, I can do it and I will do it. If you work hard with that goal, see your dreams not in night, not with closed eyes. See the dreams with naked eyes in a day, not a daydreaming. I will be not only like Harish Salve, I will be better than Harish Salve. I will be not only like Justice Chandrachud, better than Justice Chandrachud. Why can't? Have that confidence, but merely having confidence is not enough, is not sufficient one. That confidence has to be coupled with pragmatism. That you must not only work hard, you must work tirelessly, with the passion, as well as with compassion. Then only success. And success, don't measure the success by way of the wealth which we might amass in future, but measure that success, if at all possible, how well, best human being you would be. That will be the real success. I wish you all the best, not for your winning the competition, but for that being a good human being. Thank you so much.
Thank you, sir, for your words of wisdom. On behalf of the HNLU fraternity, we extend our best wishes to the participants and encourage them to seize this opportunity to grow and forge lasting connections with their peers and mentors. May this competition be a testament to their passion for law and their commitment to excellence.
May I now request Honorable Vice Chancellor Sir, HNLU, to present our guest of honor with a memento to immortalize his presence today and our gratitude for the same.
Just only one sentence. I hereby declare the first Justice Hidayatullah International Moot Court Competition open.
Thank you, sir. Proceeding towards the next part of our inaugural session, we have with us our Honorable Registrar, Dr. Vipin Kumar, sir, who not only specializes in corporate laws, but also is QLTT certified to practice as a solicitor in England and Wales. May I request, sir, to kindly deliver the vote of thanks.
Good evening to one and all. Firstly, I would like to thank the guest of honor, Professor Dr. Dilip Ukeji, Vice Chancellor MNLU Mumbai, for his gracious presence in the inaugural function. A special mention that Sir will be the convener of the upcoming CLAT, which we are going to conduct in December 2024. Sir, your presence has inspired our students and motivated them to excel in their endeavors. We are grateful to Professor Dr. V.C. Vivekanandan, sir, for believing in us and providing us with the necessary support. This event would not have been possible without the support of our sponsors, AZB partners, media partners, knowledge partners. Their generous contributions have enabled us to provide a platform for our students to showcase their talent and skills. I'll fail in my duty if I do not put on record appreciation for the entire HIMCC team led by Dr. Anindya Tiwari sir and the faculty OC members who have worked selflessly to ensure everything runs smoothly and as per the schedule. This event could not have been possible without the active participation by our student OC members and volunteers. These students have worked tirelessly behind the scenes to make this event a success. We would also like to acknowledge and put forth the efforts put by the participants. Your hard work, dedication, and enthusiasm will ensure this event's success. I cannot thank everyone enough for their involvement and their willingness to take up the completion of tasks beyond their comfort zone. Thank you for being here with us. Thanks.
Thank you very much, sir. Tonight marks the beginning of a thrilling journey for all of us as we come together to witness some of the most talented and dedicated law students across the world in the first Justice Hidayatullah International Moot Court Competition 2024.
There may be only one team which may emerge as a winner in this competition, but for each participant, the exposure gained here is what truly matters. Finally, We wish the organizers and the participants great success.
I request you all to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
With due permission of the dignitaries, we request to close the ceremony. We request the judges and faculty to proceed to the judges' lounge on the second floor for high tea. We also request the participants to proceed towards the amphitheater for high tea.